What this is addressing is State Statute 39-309, which is a law that was actually passed in 1879. It's been amended at different times. What it does is it says that trees can be planted into the roadway, not exceeding 1/10 of the legal width of the road. Your current statutes on page 52, subsection D, says that in all zoning districts, no trees, shrubs, bushes, or plants shall be placed within 10 feet of the right-of-way. And yet state statute says you can plant 1/10 of the distance into the right-of-way. York County has already been beat in appellate court on this. Board of Adjustment denied an individual's request for a variance to plant trees on the crown of the ditch. He appealed, and the court ruled that York County was in violation of this statute, that it could not be enforced in 10 feet. And what this was back in 1879, they planted Osage orange as a living fence for the control of livestock. So it's just something for you to think about as you go through the process. The next handout is regarding State Statute 23-164, adjacent territory, and notice of publication and written notice to chairperson of planning commissions. It says the notice of the time and place of such hearing shall be given by publication thereof in a legal newspaper of general circulation in the county, one time at least 10 days prior to such hearing. Notice of the time and place of such hearing shall also be given in writing to the chairperson of any municipal, county, or joint planning commission in the state which has jurisdiction over land 3 miles from the property affected by such action. In the absence of a planning commission, such notice shall be given to the clerks of units of local government. The other handout shows of 4 notices of the planning commission going to hold hearings to update the comprehensive plan. As you can see, 2 of them are only 2 days in advance, and 2 of them are only 5 days in advance, versus the state requirement that it be at least 10 days in advance. I do not know. I'm just figuring that there has been no notification of the chairmen of planning commissions within 3 miles, which involves at least 18, because it's not just Polk County and Seward County, it's also Butler County, because they tip up against us. So all the way around York County, it would involve the city of York, all the villages in York County, villages like Polk, Utica, Cordova. And there is a book that I had when I did this back in 2001 that gives who everybody is. Because like Butler County and Cordova at that time did not have planning, so you had to send to the village clerk. I would suggest that when this is done, that it also involve an affidavit of mailing being created, showing the name and to whom the planning commission represents. And what I always did is I went to the county clerk and had my signature notarized to make sure that if it came up in a court situation, that it would, be handled properly. This involves Nebraska State Statute 23-114.01, County Planning Commission appointment. I've highlighted for you the line, members of the commission shall hold no county or municipal office. In this case, last time I talked to the county clerk, the chairman of the planning commission is also your county surveyor. On page 2, you will see where I sent a request to the Nebraska Board of Examiners for Land Surveyors of Lincoln. Page 3 will be their response. They say filling the office would be considered to be holding a county office. The opinion of this office is yes. The office is the county surveyor, which is a county office. So if you go back to that original page, members of the commission shall hold no county office. Here it states that that individual is considered to hold a county office, that of county surveyor. So it would make him be ineligible to be on that board. I do want to say I think he does a great job. He always has, but it's just, you know, we're into technicalities, I guess. This last handout is regarding a court case that York County had. You'll see on the front there where they took a rural York County garbage hauler to court trying to get his bad business closed for violation of zoning and also being a public nuisance. Initially, Judge Bryce Bartu ruled that the individual had to close his business. He appealed to the Nebraska Court of Appeals, and there's quite a few places circled and highlighted. But the thing is, the conclusion of the appeals court on page 10, we find the zoning regulation under which the county sought to enjoin Tracy from operating his business to be invalid. This was when York County created zoning in 1974. They failed to have a public notice in the York News Times concerning the fact that a hearing was being held. It was not on the agenda, and there was no minutes taken that the board had a hearing or that they voted to adopt zoning. So the court concluded in March 31st of 1996 that the county zoning was invalid. The second handout shows a public notice that was done in September 28th of 1993 where the county was updating, they claimed. The thing is, they knew, the 5 commissioners at that time knew that there was a chance that they'd be overturned in appellate court. So they did what they called considered proposed changes to the county comprehensive plan, zoning map, and zoning regulations. But never since the appellate court ruled in 1996 has there been any actual adoption of a comprehensive plan or zoning rules and regulations. They have just merely updated all the time. I guess this is something that you have to rely on your county attorney, but they never adopted. It was ruled invalid. All they did was keep updating something that had been ruled by the court invalid. So my fear is if you just update again, that you're if you get into court because you've got a pretty volatile issue that you're addressing all the time, that it could be thrown out that it's never been adopted. I told Ms. Deck that, you know, I did work for the county for 10 years doing zoning and floodplain, and if she ever has any questions, I'll help her for free. You know, just give her my background. Because, I mean, it's pretty tough, even like with your new zoning administrator. How do you go into something this complex with no training? When I was hired, Commissioner Stewart walked down the hallway and said, "Hey, you want another job?" An hour later, I was zoning administrator. I found a file cabinet shoved in a hallway and a door locked to the road department that was doing it. And I just sat around and I read the law. I studied. That's how I came with this. And I just felt with all the issues you've got coming at you that it's just imperative that some of this be addressed, or all of it, I should say. And I would hope you could do it quickly, because if it's the year time frame, and you know, if your attorney says, well, hey, all these other hearings were not legally held because they weren't advertised 10 days in advance, the chairman of the planning commission wasn't notified, you start over, it can't be a year process.